Now we'll be starting with the Indian Contract Act 1872. So in this video, we'll primarily focus or first focus on the previous law of state. So how has it all evolved for now the Indian Contract Act? So the previous state of law. So primarily in the initial days, the English law was based on the local circumstances and it was in the presidency places and the presidency towns were Madras, which was Chennai, Bombay, which is Mumbai, and Calcutta, which is Kolkata. So English law was based on local circumstances in these presidency towns based on the charter which was granted by King George I to the East India Company. So English law was based on local circumstances with the help of the charter which was granted by King George I to East India Company. And this was valid to the presidency towns, and in the year 1781 they have passed the Act of Settlement, which was passed by the British Parliament, which has also followed in the presidency towns itself. But what about the towns which are outside the presidency? So outside the presidency towns, they were called the mafusils, and they were working on the basis of justice, equity, and good conscience. So in the presidency towns, it was based on the Act of Settlement by the British Parliament. So this Act of Settlement was followed in the presidency towns, and for outside the presidency towns, which were the mofusils, they followed based on justice, equity, and good conscience. Moving on, the Contract Act 1872. So this contract has basically come from a Latin word which is contractum, which means drawn together. So this Contract Act deals with the following things, that is the sale of goods, indemnity and guarantee, law of bailment, agency and partnership. So we'll be studying about them in much more detail in the future, but for now remember that the Contract Act deals with the following aspects. And in the year 1930, the Act on Sale of Goods was passed, and in the year 1932, the Indian Partnership Act was passed. Apart from these two, there were no much changes made or no much enactments were made for this Contract Act of 1872. Let us take a quick overview of what is a contract. So, let us say A has come up with a thing which he had told to another person. So, when A had said something to B, either to do or to abstain from doing, then that particular thing, whatever he had told, will become the proposal. So, A has sent a proposal to B. So, if B has shown his willingness to do what the proposal which was sent by A, so if B has accepted this proposal, then that particular thing will become a promise. So basically A has sent a proposal to B and B has accepted the proposal, and then it becomes a promise. So when this promise has come into place, then this particular A, that is the person making proposal, will be called the promiser, and B, who is the person accepting the proposal, will become the promisee. So these are important to remember, that A has become the promiser because he was making the proposal, and B had become the promisee because he was the one who has accepted the proposal. So after making the promise, if that promise is followed by these people, then it will become a consideration. So it will become a consideration. So initially it was a promise. After it has been followed, it has become a consideration. The consideration of promise. So after consideration, there comes into play the agreement. So every promise, every set of promise forming the consideration for each other is an agreement. In agreement, we have two kinds. That is an agreement which is not enforceable by law, and an agreement which is enforceable by law. So an agreement which is not enforceable by law is said to be void, and an agreement which is enforceable by law is said to be a contract. So void in the sense it is not valid, and an agreement which is enforceable by law is valid, and therefore it is called a contract. So overall, we have seen that the person who has made the agreement or making the proposal is called the promisee, and the person accepting the proposal is called the promisee, and the person making is called the promiser. And if A sends a proposal to B, then if B accepts it, it becomes a promise, and if the promise is followed, it becomes a consideration. By consideration, a particular proposal will turn into an agreement. So the promise with consideration will turn into an agreement. An agreement can either be enforceable by law or it is not enforceable by law. If it is not enforceable by law, then it is called void, and if it is enforceable by law, then it will become a contract.